Everyone, my name is Ruby Powers. We're going to talk about what happens to your case after dismissal in immigration court. This is becoming such a common thing that's happened the last couple of years, unlike many years before. And so we wanted to do a webinar about this. My name is Ruby Powers. I'm a board certified immigration attorney, and I'm talking on behalf of Powers Law Group. The firm is 15 years old. I've been practicing 16 years, and really just wanted to share as much information that we have available here. So um, the U.S. government, under the Department of Justice Executive Office of Immigration Court, EOIR, Executive Office of Immigration Review, has been dismissing a lot of cases. There were millions of immigration court cases piled up, and with prosecutorial discretion and with review of what the priorities are, um, we've been seeing a lot of cases get dismissed. So what does dismiss mean? It means you're not in court anymore. And what we've seen was a higher a number of those of people who had arrived before around the pandemic, before that time. And it means that you're no longer in immigration court proceedings. Now, generally what happens is by getting a notice to appear, it's summoning you and putting you under jurisdiction of having immigration court. And if the case gets dismissed, other times we use the word terminate, but they can mean a little bit differently. Then that means that you are no longer in immigration court. So this is something that can happen to asylum seekers, but not just asylum seekers, those who've been in court for who have other things applying for cancellation of removal, U visa, T visa, TPS, a lot of different things. So anyway, this is something that can affect a lot of different individuals, and so we want just to sort of explain it. Now, a lot of people are like, well, what happens if my case gets dismissed, and what about my work authorization? Well, the thing is that technically it really depends on whether the application, the form of relief that you had was only allowed to be applied for in immigration court. Now, what does that mean? Well, if you had a cancellation of removal case, well, that's only if you are in immigration court defensively. So if your case gets dismissed in immigration court, then that means the cancellation of removal is no longer pending, which means the basis of your work authorization is no longer valid. Okay, so let's say you applied for asylum affirmatively, it gets referred to immigration court, and you are in court and your court case gets dismissed. Well, then that means your asylum case is no longer pending. And so you would have to reapply for asylum to be able to apply for work authorization. So these are things to consider when you are applying, when you're thinking about whether to get dismissed or not. So if you apply for a renewal of your work authorization and it's still pending, by the time you dismiss, very likely that work authorization will get denied. And that you would need to apply anew, for example, for asylum, to be able to wait or ask for those dates to be recaptured to be able to submit the work authorization. So let's say you've never received a work permit before, you can apply after your case gets dismissed to applying for a new asylum application with USCIS. Then you wait 150 days to apply for work authorization. Now, this can depend on whether you can recapture the filing date that you applied before, and therefore, if you could do that, then you can use that old filing date and not have to wait the new 150 days. But in my experience, it sort of takes a while for you to even try to recapture that date to be able to save the 150 days. So I would say, talk to us more specifically about your case, what's going on at the time, but this is another consideration that happens. Now, if you have a work permit in your hands and then you get your court case dismissed, then you would have to apply for something new. Now, webinars really focus a lot about asylum, but it's not just about asylum. So it really depends on what your other form of relief is. Like, for example, if you have TPS, Well, TPS is with you apply with USCIS, and your work authorization is nothing to do with what's going on in court. So and that's what really matters, is to look to the price, to look to see what is the basis of your work authorization. So, and that's another thing to consider. You could have had a work authorization based off asylum pending and one off of TPS. But if your court case gets dismissed, your asylum will no longer be pending, and you would have your work authorization based off of TPS. So these are some things to consider when you're deciding when to dismiss, if you have control over that at all. Um, Now, submitting additional documents or renewing the application while it's pending, these are things to consider depending on where you are, what you've applied for in the process. But what happens to the asylum case when your court case gets dismissed? Well, it's like it just doesn't exist anymore, if you will, because it's not pending anymore. It's still there was a record somewhere. So, in fact, when they say they dismiss without prejudice, it means that they can reopen it later if they wanted to try to put you in court again. And so that's always fair game, and that record that was already submitted could come up in some other future petition or application. So you do need to be cognizant of that. But if the bottom line is, if your court case is dismissed, then it's not pending anymore. But one day it could be reopened if they wanted to do that, if they have the right means to be able to summon you into court again. If so, let's say you get your court case dismissed, and if you don't have any other form of relief to stand on afterwards, well, then you definitely want to have a consultation to evaluate what maybe you do have something you didn't know about. But then that would mean you really wouldn't have anything if you don't file for something new or didn't fall back on something that was already filed with USCIS. And so that was something to consider. If you had your court asylum pending in the court and then you get your case dismissed, and you want to apply for asylum again, you can. This is sort of a new territory. We've only been seeing it for about 2 years, I think, 2 or 3 years. I've sort of lost track now. This is something we never really saw before. So a lot of our clients that we've filed the new asylum applications with USCIS after we get them out of court, we've been getting them work authorization. We haven't had any of them have interviews yet, but we've heard people say some people have, because under LIFO, last in, first out, some folks have been getting interviews that applied. Okay, so you would want to, if you got your case dismissed in court and you want to apply it new for asylum, you would want to apply it as soon as possible so there's not much of a lapse and you can show that it was reasonably filed and not being considered late. And so this also matters to about how you file it. The rules are sort of always changing, and for the most part, the last I checked, you can't apply online in this certain circumstances. You'd have to file over paper, but they're always changing these things. Now, you could have had another form of relief, like we said. You could have had a TPS, an I-130, a U visa, a cancellation or removal. When your court case gets dismissed, the best way to think about it is whatever was applied for only in court in a defensive way, which is very few things that I could think of, but mostly the big ones are cancellation of removal for 42A, 42B, and I-589 could be for defensive. Then those things are not pending anymore after it's dismissed. But if you had filed for a TPS, an I-130, a U visa, those things still exist at USCIS. And so when you get out of court, you're not having to deal with court. You're not having to attend the hearings and follow all those rules and have that jurisdiction hanging over you. You can then go to be focused only on USCIS and what's going on over there. Now, one thing that does become an issue is if a person had an I-130 approved and they had a 485 in court, which you can only file the 485 in court after the I-130 gets approved. is that then there's this limbo place of where what happens with the I-45 because the fee has already been paid. And if you dismiss the case and just get it moved over to USCIS, I will tell you this is a big limbo place. It's usually best to, it has been our experience to either not file the 45 in court and either just file the 45 with USCIS and try to get out of court before you have to file the 45 in court for any whatever reason. So there's a lot to this, and hopefully that made sense. But just wanted to say that this is a new space the last couple years, and we have a lot of experience with this with court cases around the country. Feel free to reach us at 713-589-2085 online, X, TikTok, Instagram, newsletter, Facebook. We're there. You'll find us. Stay connected with us, English and Spanish. We got that material out there for you. So this month we've got a lot of exciting things. We talked about perm, filing mandamus, what happens when your court case gets dismissed in immigration court, and we're going to be talking about can my 21-year-old U.S. citizen child, who's not really a child anymore, right, petition for me, and what happens? What does that mean? So thanks so much for watching. Please feel free to share with a friend, a loved one, a neighbor, somebody who might use this information, find it valuable. We're here for you. Again, my name is Ruby Powers and with Powers Law Group. Thanks for watching.